This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawuna Matanda.
I'm BJ Lomsal.
And I'm Jennifer Raphael. In this episode, we're featuring another conversation recorded at the 2025 SoCLA conference. I was lucky enough to speak with Matthew Bell, Associate Professor at Melbourne Law School, and Trevor Thomas, Partner at Corr's Chambers Westgarth. We spoke just after they finished their talk at the conference about low-value liquidated damages in residential contracts. But through the use of AI, they managed to create quite a unique presentation. In today's chat, you'll hear how homeowners can be left vulnerable under standard form contracts, why the law around liquidated damages needs greater certainty, and what happens when Shakespeare's Merchant of Venice meets modern construction law. Let's get into it. Matthew and Trevor, welcome to the show.
Thanks, Jen.
Thank you very much.
Let's get started. For anybody who wasn't at the very entertaining presentation that you did this afternoon.
Shame.
Yes, shame. Can you briefly explain what your presentation was about? Maybe Matthew, if we start with you.
Our presentation was about liquidated damages and the application of doctrine to low-value liquidated damages. But then it sort of morphed into something else, largely because of the time of day that we're actually giving the presentation. And Trevor, do you want to sort of say what we did?
So we prepared a paper which was done in a fairly serious manner. And then we thought, well, what might be fun is we're both quite obsessed with the podcast The Rest is History. And we thought, well, why don't we do the presentation in the style of that podcast? And so what we did is took the paper and uploaded it into Copilot, and it produced a script in the style of The Rest is History.
Yeah, so when Trevor says, why don't we could think of a few reasons why we shouldn't, including that we didn't want to insult our heroes, Tom and Dominic, but we gave it a go, and with Copilot's help, pretty quickly it actually produced something which was astonishing and terrifyingly plausible, which we then top and tailed, added in something about the world's greatest monkeys, and before we knew it, we'd actually had exactly what we'd asked Copilot for, which was a 15-minute script.
And may I commend our history's greatest monkeys to the listeners. It is an amazing episode, and everybody should learn about Jacko Macaco.
The paper in your presentation has some colourful references to Shakespeare's The Merchant of Venice. What made you use that and draw the analogy to liquidated damages?
So one of the things about liquidated damages is that the origins of it have been lost in the mists of time. Some people say that it came to the fore during the Black Death, when King Edward was trying to re-establish the state with only half the population. Others have said that it was really brought to life in the early 20th century through the case of Dunlop. But that was really just a restatement of the existing very muddy law. So we thought we'd not go as far back as the Black Death, but because Justice Gordon and others in judgments have referred to the penalty bond, which is, of course, the basis for the Merchant of Venice, and won't give any spoilers here for what actually happens between Shylock and Portia, but it doesn't come to a very good end for poor old Shylock. We thought that might be a good way to engage people, especially, as we said, at 20 to 5 after a very long day of conferencing.
I think the period for spoiler alerts has ended.
I'm sure you're right.
As we approach the anniversary.
Yeah, it's nearly 500 years. So
yes,
probably
yeah,
most
I
people
don't
know
think you're spoiling anything there. So your paper deals with low value liquidated damages, which is something that really applies in residential building contracts as opposed to more commercial
construction contracts. And in your paper, you mentioned the case of Carboni. Can you explain why that case is important?
It's a good demonstration of how this issue can arise far more frequently than one might imagine. It's really contingent on the HIA standard form of contract, which has a provision for liquidated damages. And it's certainly, the outcome is that if you don't fill in the amount, the default rate of liquidated damages is $1 a day. And so, whilst one might think it's a particularly unusual event, it happens far more frequently than you would otherwise have thought.
Yes, it's very rare for the builder or the owner to fill it out with another rate. So the default rate will usually apply.
Yeah, and as some of the discussion, really useful discussion afterwards pointed out, from the builder's point of view, this is done for a very good reason, because the builder, or at least the HIA representing them, their lawyers, know that if you leave the damages open, then potentially it could be a very large amount of money that the builder has to then stump up at the end of the project if they are late. So the ability then to say, well, not only will you not get any general damages that you can prove as a matter of breach of contract for late completion, but then also your daily liquidated damages will be limited to $1, which is virtually nothing, is a very useful thing from the builder's point of view. But to even go through that explanation, I think, for a optimistic home builder, and there's thousands of these contracts entered into every year in New South Wales alone, then it's a very difficult thing to actually get your head around, and it can be very dangerous if you don't understand what you're signing up to.
Of course, and in the residential building space, we're dealing with often unsophisticated clients who are not familiar, potentially haven't even read the terms that they're signing up to, and only when it's becoming a problem and getting legal advice, realising that their capacity to pursue the builder for late completion is rather limited, potentially.
That's precisely right, Jen. And with that in mind, for the Carbonis who have been through that process, have signed the contract, didn't make a difference to the default clause, and then have gone all the way through the New South Wales District Court and all the way up to the New South Wales Court of Appeal, and then they finally get, well, in this case, the outcome that they were looking for. That's far too much for people to have to go through to enforce their rights, when perhaps just a 5-minute listen to this podcast, for example, might have alerted them to the fact that you really do need to do something about liquidated or general damages at the time you enter into the contract.
So on the one hand, it's the need for the consumer protection, which is obviously heavily prevalent in the residential building legislation in the various states. But on the other side of it, and I think this is some of the points that you guys made in your presentation, is the role that the court has to play in looking at the commerciality of these things. So, Trevor, what are your thoughts on that?
It's an interesting point that it's sort of counter to our argument, but if we accept that it's not really the role of the court to step in and try and give commercial meaning to the consideration that flows in a contract, so if we accept the proposition of, well, $1 consideration is, as long as there's that, then you can't question whether that's an adequate commercial structure of the bargain or amount for the bargain. So I think that's an interesting role to sort of juxtapose to this position. It is, well, is it really up to the court to say, well, $1 is equivalent to zero? Why is it okay in considering consideration, but not okay in considering the rate of liquidated damages? So I think that's the sort of other side of the coin.
Yes, that's right. So turning to that now, your paper proposes that the penalty doctrine apply to low-value liquidated damages. So for those who are maybe not familiar with what that is, how would that work?
So, and again, we're looking at the modern formulation of the penalties doctrine, which in a nutshell, and it's been the subject of a number of cases most recently the Pachioko case, which we're not even sure how best to pronounce that, let alone what it actually means. But according to that case, we're looking at the old test from cases like Dunlop, which is really about looking to whether there has been a genuine pre-estimate of loss, or conversely, whether the amount of liquidated damages is out of all proportion to the maximum conceivable loss. But then they've also introduced this concept of the legitimate purpose supporting that aspect of the test. So from that point of view, at least from the commercial point of view, there's been a lot of commentary, which I think is right, that in the last 10 years or so, the case law has made it more difficult to overcome liquidated damages, especially due to the introduction of that legitimate purpose test. But I guess the main question here, Jen, is what does that actually mean in the context of residential building contracts? It's an incredibly complex matrix you have to unravel. So in saying that we should apply the penalties doctrine, we're not, as Trevor said before, we're not saying that this absolutely is the way that things should be done, but it's something we'd like to explore, mainly from the point of doctrinal certainty. So rather than falling back on these ideas of contract interpretation, which themselves are open to a lot of interpretation, we'd actually be suggesting that we apply the penalties doctrine no matter what the liquidated damages are, whether they're $0, $1, $10, or for that matter, hundreds of millions of dollars, as we heard about in other cases today.
And I hope it comes through clearly in the paper, is that the approach of looking at these values from a contractual interpretation perspective is one lens to apply, and seems to be the orthodox way of approaching it. And we're just trying the alternative of, well, why shouldn't the penalties doctrine also apply in reverse?
So the contractual interpretation lens being, as per Carboni, that if you're having a liquidated damages provision at nil or $1, it's not providing an exclusive remedy for damages for breaching that obligation and leaving it open to general damages.
That's right. I mean, we're looking at an alternative test, really. And what we've identified, because the cases flip-flop around through the use of the current interpretation technique to try and work out whether the parties have agreed by clear words to exclude their right to general damages, we don't think that the law is adequately certain in the way it's being applied. So instead we're suggesting, well, why not? And we're really putting the question out there, why not apply the penalties doctrine to these low-value LDs as well as to higher-value LDs?
Are you, either of you, aware whether it's been argued before in the courts to apply these to low-value liquidated damages?
As far as we're aware, it hasn't been. I would say, just putting on my academic hat for a second, I think that's exactly the purpose of this sort of conference, to bring an idea along, to float it up there, to see who might say, oh, well, that's a balloon that might go a little bit higher, or in some cases to prick the balloon and it falls down to earth. But very helpfully, we got some suggestions at the end that people thought there might be something in it.
Yeah, definitely. I think that's really great thing about these conferences, is to exchange these kind of ideas amongst colleagues.
Can I just feed you a line though, Trevor? Something like, the law is a very blunt instrument. It's not as sharp as Porsche's knife, or something like that. I don't know.
Do you have a final statement that either of you would like to make?
I'll have a go. So if you'll permit me to go back to the 16th century again and back to Venice. And of course, we're all worried about the sharpness of the knife which was going to be plunged into that chest. But I would have to say that the law is nowhere near as sharp as that. The law can be a very blunt instrument.
Bravo.
Boom. Done. Thank you so much for joining us on the show.
You're welcome.
Thank you.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career, with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au.
This show was produced with strategy and production support from Wavelength Creative.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawana Matanda.
I'm Vijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.